everyone. My name is Sheza. In this presentation, I'm sharing a summary of a small claims court interpreting training course, which I've been doing with my colleagues in Jordan. In the next slides, I'll explain what small claims court interpreting is, and what interpreters need to do to be professional. Let me start by asking 3 questions. What is it? Who's involved? How does it all work? So let's start by talking about what a small claim is, and what interpreting is. A small claims case in Jordan is a civil dispute, brought to conciliation court. There are a few things that make it different from other types of civil cases. First, the rules and procedures are a lot simpler. Small claims court is cheap, and usually gets things resolved quickly. In a small claim, the subject matter isn't different from a normal civil case, but the amount claimed is less than 1,000 dinars. Essentially, interpreting is the process of translating a speech into another language. In this method of communication, a message is relayed from one language to another by saying it out loud. In fact, that is the main characteristic that sets it apart from written translations, and it is for that reason that interpreting is often viewed as a special talent. The reality, however, is that there exists a mode of interpreting involving written work, where an interpreter interprets orally a message that has been presented in a written format. In this instance, we are referring to sight translation. There are 3 main types of interpreting that are worth mentioning here. Simultaneous interpretation is when an interpreter listens to the original speaker and interprets what they're saying in real time. Conferences usually use this mode of interpreting. Secondly, you can do consecutive interpreting. This mode lets the interpreter interpret a few chunks of words or sentences every now and then. The original speaker would make pauses to enable you to do this. We use this mode for field visits, small meetings, and court proceedings. Thirdly, we'll talk about sight translation. It's possible that someone has a document written in a language they don't understand. You're an interpreter, so you tell him what the source language says in real time. In this sense, it is similar to simultaneous interpreter, except for the fact that the source text is a written document, not an oral message. I'll start with the first 2 questions. When is the small claims court going to need interpreters? Which mode of interpretation should we use? Well, the court uses the official language of the state. So, what happens when a litigant does not speak that official language? In fact, the judge needs to make sure that this language barrier does not affect justice. This is when the judge calls for an interpreter. You'll be asked to interpret for the judge what the litigants say, and to relay the judge's question back to them. For the second question, we're supposed to interpret consecutively. The speaker says something, pauses, then lets you interpret it in chunks. Many people are present at court, including the disputants, that is the plaintiff and the defendant. There can also be witnesses, lawyers, and experts. In the next slide, we focus our attention on two persons. There is the judge, who makes the big decisions. There is also the interpreter, who relays messages among the interlocutors. So, let us first talk about the judge. The judge is the one person who has the authority to decide a case. His ultimate goal is to know why a dispute has happened. Is there any legal relation between the disputants? Is either of the disputants is responsible for some damage that has happened to the other party? He gives the disputants equal opportunities to talk and the right to be listened to. Finally, he makes a judgment. Achieving justice is the ultimate goal of the court. In this sense, the judge's decision must be just and fair. Pursuing justice involves a process that judges follow when hearing, hence, deciding a case. First of all, the judge should be neutral. Neutrality means the judge will not take sides with either party to the dispute. For example, the judge will not have compassion for one party and deaf ears for the other. This is even if, in the depth of his heart, he knows which party has a rightful claim. Judges deal with disputants on equal footings, very neutrally, that is to say. Having acquaintance or personal relations with either party may severely affect the outcome of the case. Therefore, judge's neutrality implies that he does not know either of them. The second trait of a judge is that he is a listener. He hears everything that the plaintiff and defendant say, to conceptualize the facts of the dispute. This also means that he cannot simply listen to one party and ignore the other. The judge cannot take things for granted. Think about a plaintiff claiming his car got damaged by the defendant. The judge cannot just leap to the conclusion that it was a wrongful act, just because it is a known principle in life that people should not damage others' property. The fourth task of a judge is to look into the written evidence and listen to personal testimonies, if available. In this way, he is trying to establish facts. After doing so, he can look into the source of obligation between the disputants. Then, the judge checks what the law says, applies it, and concludes the hearing with a judgment.